Okay, very few people in the class so far. But let's get started. I am recording, so people that join late can always listen to the recordings. We only have 2 more units left to do, Unit 21 and Unit 22. Then we have actually finished the semester's work. But I will also, closer to the exam, so like the week before the exam starts, I will also have a comprehensive revision class where I will take you through the structure of the exam and all of that to assist you with your final preparations. I will also, prior to the exam, set up another practice quiz, but then containing all the units, just to assist you also with your preparation for the multiple choice questions. I found that that is very beneficial. Test 2, lovely results. There were in excess, I've already said, in excess of 700 attempts for this practice quiz. And the results really reflected the effort you were putting in. So what we looked at Tuesday is the concept of a close corporation, as well as the requirements for membership. Who may be members of a close corporation? What we're focusing on this evening then is, once you've got your close corporation up and running, how are the internal relations, how are the matters of the close corporation handled between members? So internal relations. Next week then we look at external relations. Essentially, when are close corporations bound to contracts entered into on its behalf, as well as certain instances of personal liability of members. But focusing then today on internal relations. How are things structured inside a close corporation? So your learning objectives, remember to always go back to them and make sure that you have met those objectives. Starting off internal relations, looking very briefly at certain common law duties of members of a close corporation. What I'm saying very briefly is, you know this. You essentially know this. As is the case with company directors, members of a close corporation have both got a duty of good faith as well as a duty of care and skill. Remember what I warned you when we were doing directors' duties? These are separate duties. Don't mix them up. There's no such a thing as the fiduciary duty of care and skill. No, that's wrong. There's a fiduciary duty, a duty of good faith, as well as a duty of care and skill. The contents of these two duties I'm not going to discuss with you because it's a repetition of what we did when we did companies. Good faith is good faith is good faith, whether you're a company director, a partner, or a member of a close corporation. Similar to company directors and in partnerships, should the corporation suffer a loss as a result of a member's breach of their duty of good faith, the corporation has a claim for any such loss suffered, but also your secret profit rule. If you benefited, if you kept for yourself a benefit that should have been shared with the corporation, the corporation also has a claim for that benefit. Duty of care and skill, that's essentially falls within the law of delict. If you were negligent in your management of the affairs of the closed corporation, or in the manner you used any property of the closed corporation or whatever, you did not act with the necessary care and skills, in other words, you were negligent, the closed corporation can claim damages. But as is the case for any claim for damages, if the corporation wants to claim damages, they have to prove that they actually suffered those damages. Where matters are slightly, where the closed corporation is slightly different from the Companies Act, is that the closed corporation provides that members can condone, forgive, decide not to claim. In the event of a particular member having breached either the duty of good faith, but more specifically the duty of care and skill, the other members can decide not to claim, to condone, to forgive this member. Requirements for such condonation is that approval for the condonation must be given in writing by all the members of the corporation, who must be fully informed of all the material facts. This implies that what is referred to as a blanket approval in an association agreement will be invalid. A blanket approval, that's the term that we use to describe a general approval, a clause in an association agreement stating that the corporation will always condone breaches. No members will ever be held liable. That would be invalid in an association agreement. This condonation can only be given at a particular time if there was a particular breach. All the members are aware of the material facts and can make up their mind, make a decision, do they wish to condone this or not. This condonation, however, does not apply. No approval can be given for a member's failure to properly exercise their managerial powers or to represent the corporation in the interest and for the benefit of the corporation. Which is why I said this condonation primarily applies to cases where there was a breach of care and skill. Due to good faith, you have to act in the best interest of the corporation. That if you don't, that cannot be condoned. Okay. Moving on then to something new. We saw on Tuesday that when you register a closed corporation, there are two founding documents, namely the founding statement, which contains the important details, members' interest, etc., and an optional association agreement. So you don't have to enter into an association agreement. This association agreement can also be entered into at any time. It doesn't have to be when the closed corporation is first registered. It can be done at a later stage, should you want to. What is an association agreement? It's a written agreement between members of a closed corporation which regulates their internal relations. So similar to, in function to, your articles of association. Similar to the constitution of the company, It forms a contract between the corporation and its members, as well as a contract between the individual members. In addition to association agreements, the law also permits members of a close corporation to enter into additional agreements, which are referred to as other agreements. So you get an association agreement and you get other agreements. Your association agreement must be in writing, must be signed, and it must be kept at the registered office of the close corporation. So it's not registered with BIPA, but it must be kept at the registered office of the close corporation. Important thing about association agreements is that if there is an existing association agreement and a new member joins the corporation, they automatically become bound without having to physically sign it. They also remain bound even if they are no longer a member. So, similar to the constitution of a company, members that become members after registration are bound to the constitution, although they have not physically signed it. Same concept, you're bound to the association even though you have not physically signed it. Other agreements are more informal. They can be, but they don't have to be in writing. Obviously, if they're not in writing, they won't be signed and they can't be kept at the registered office. And only members who were members at the time will be bound to such informal other agreements. Why does the law recognize both association agreements and other agreements? To provide even more flexibility. Let's say Alicia, Elena, and Rodrigue are the three members of our close corporation. And their association agreement states that Alicia is the managing member and she is the only member who may represent the close corporation in contracts. But now Alicia is going on holiday for an extended period of time. She's going to be out of the country for 6 months. Obviously, business needs to continue. The fact that she's not around doesn't mean now the business must stop. That would be impractical. So they can then informally agree that during her absence, Rodrigue will represent the close corporation. So they don't have to then enter into a whole new association agreement. And when she comes back, enter into another whole new association agreement. They can enter into an informal agreement for a specific period of time to fulfill a specific function. Practical arrangement just adds more flexibility to the management of a close corporation. Now, looking at the contents of an association agreement, what may be in an association agreement and what may not be in an association agreement. The Close Corporations Act contains certain rules that we describe as unalterable rules. Unalterable, they cannot be changed. These are statutory provisions that will always apply. So you cannot try to change them. If you try to change them by way of an association agreement, it will be valid. They cannot be changed or altered. Two of the important unalterable rules are the statutory provisions regarding members who are disqualified from managing the business of a closed corporation. We look at that next week in the next unit, as well as the right of any member, irrespective of the size of their members' interest, to call meetings. Also, what we looked at the previous slide, that consent to condone breaches of the fiduciary duty and duty of care and skill requires written condonation of, or written approval of the condonation by all members, who must be fully aware of all the material facts. And that provision, that it can only be under those conditions, can also not be changed. This last piece that I have there is, in fact, a repetition of what I've said there. So it's not a new thing. It is just a repetition of what I've already told you in that slide. So these are unalterable rules. They cannot be changed. In addition, the Closed Corporations Act also contains what are described as variable rules. Variable rules, management rules laid down in the Closed Corporations Act that will apply unless they have been changed by way of a formal association agreement. So these are the default provisions regarding internal relations of a closed corporation. They will apply unless members have decided to change them to suit their specific requirements. Some of these variable rules, we look at this one as well next week on Tuesday, or these first two. Every member is entitled to participate in the carrying on of the business, and they've got equal rights regarding management of the business unless they were disqualified. Variable rules that can be changed to suit your particular purpose. You can decide in your closed corporation that you're going to make Alicia your managing member. Variable. Another variable rule, differences are decided by majority vote at meetings. That's the default position. Related to this, the number of votes correspond with a percentage of the members' interest. So both of these relate to meetings. Our unalterable rule is the right of any member at any time to call a meeting. The procedures at that meeting can be changed. Default position, majority vote, calculated in accordance to the percentage of members' interest, but the closed corporation can, for example, in their association agreement, agree that it's not majority vote, but it must be consensus. Everybody must always agree that irrespective of percentage of members' interest, it's one person, one vote, whatever suits your particular purposes. Another variable rule, payments by reason only of membership made in proportion to the member's interest. That bit there. Payments by reason only of membership relate to, is the closed corporation speak for dividends. So it's not a salary that you get, it's a dividend payment, a payment that you get purely because you are a member. Default rule, in proportion to members' interests. So majority members will get more. You can change that irrespective of members' interests, everybody will get same amounts. Once again, Flexible can be changed in an association agreement to suit your particular requirements. Looking quickly at meetings of members, we've touched on meetings of members so far, or briefly mentioned that any member at any time has the right to call meetings. Close corporations don't have to have an AGM, an annual general meeting. There are no compulsory meetings required except at the winding up of a close corporation. Unalterable rules: any member may call a meeting and all members must be notified. The default rules that will apply unless changed is that meetings must be held at a reasonable date, time, and venue, reasonably suitable for the members. So no requirements, 14 days notice, 21 days notice, 28 days notice, no, just as long as it's a reasonable time and everybody's been given notice. 3/4 of the members must be present to constitute a quorum. Once again, that can be changed. You can decide that 50% is enough, whatever, but the default position, 3/4. No proxies are allowed. Have to attend in person. And the minutes of the meeting must be prepared and circulated, shared with the members within 14 days. You can also make decisions without having a formal meeting. A round-robin resolution, a written resolution signed by all the members, is also regarded as binding. So payments to members, dividends, we don't call them dividends, but it's the same thing. Can be done from any source. Requirements that have to be met: these are your typical close corporation requirements. Corporation must be solvent, must be liquid, and after the payments have been made, it must remain liquid. So remember this, in companies when we had these requirements, for example, purchase of their own shares, we only had 2 requirements, solvency and liquidity. In close corporations, we have 3, solvency, liquidity, and it must remain liquid. Loans to members. Close corporation can lend money to a member. Order for close corporation to lend money to a member, there must be express written consent of all the members. And that's it, short and sweet. That's how things work inside a close corporation. Any questions? Okay, so we finished nice and early tonight. Thank you for the few of you that did join. Class was particularly empty tonight. But that's okay. I have recorded. I will share the slideshow on YouTube, the recording on YouTube as always. So we only have one more unit to do, and then we're done with company law, which is actually quite sad because I enjoyed teaching you. But I didn't enjoy teaching you that much that I want you to fail, that you can be in my class again next year. Ms. Namu says you're allowed to pass. I like you a lot, but not that much that I want you in my class again next year. Okay, wonderful. Thank you so much. Bye.
Thank you, ma'am. Good night.
Thank you, ma'am. Bye. Good night.
Good night, ma'am.
Good night.